Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled Canadian Maritime Law Update 001 through 008 Combined. Aspect of arrest of vessel in Canada. The jurisdictions in realm of the Federal Court of Canada is outlined in the Federal Courts Act. It must be established by the arresting party that at the time of the commencement of the actions, the ships, aircraft, or other property that is the subject of the actions, a qualifications not present in the UK stated, is beneficially owned by the person who was the beneficial owner at the time when the cause of actions arose. The Supreme Court in the Phoenix Bull Carriers decisions has held that the court in rem jurisdictions may be exercised with respect to claim for shootout cargo and dead freight, so long as the cargo to be arrested in the cargo at issue. For this reason, arrests of ships' bunkers are rare unless the bunker involved are the bunkers in dispute, not merely the property of the personal defendant. A demise charter has been held not to be a beneficial owner of a vessel under the meaning of Section 43, Part 3. The concept of beneficial ownership has been narrowly interpreted and does not include related or closely associated companies, unless serious reasons can be shown why the corporate's will can be lifted. Inaction syndrome is sustainable only if the owner is personally liable for the amount claimed, a requirement which is particularly acute in the case of claim for necessaries or where owner has authorized a person to contract on the credit of the ship. There is an exception to that rule when the court is requested to enforce a foreign maritime lien for necessaries or the new Canadian maritime lien against foreign vessel for services, supplies, and repairs. Deserters and stowaways. Pursuant to the Immigration and Refugee Protection Act and the Immigration and Refugee Protection Regulation, when a desertion or a stowaway is reported, cash security must be deposited with the immigration authorities. The amount is discretionary, but the informal policy of the Department of Immigration is to require between $15,000 and $25,000 per deserter depending on various factors such as the ship's past record, the cost of repatriations, medical costs. From the case deposit, a standard administration fee of $3,200 is deducted. When the deserter or stowaway case have been concluded, either by way of deportations or by granting of landed status, the unused portions, if any, of the remaining fund is reimbursed to the transportation company. If the repatriations and or medical costs exceed the amount of the deposit, the authorities will seek to recover the balance from the transportation company. Under the Act and Regulation, the range of responsible persons includes anyone who owns, operates, charters, or manages the vessel and the agent for that person. The agent includes any person in Canada who provides services as a representative of a ship owner, a ship operator, or charterer. As a consequence, a time of voyage charterer has a statutory liability and perhaps an insurable interest. Foreign liens and lien clauses in Canada. Canadian and U.S. court follows a connecting factors analysis in deciding the law that governs contract and liens and will give effect to a foreign lien once it is properly proved as fact according to the rules of evidence. Neither Canada nor the U.S. are signatories, not bound by any international conventions governing arrest of a ship and applicable liens. As well, neither country considered the questions whether or not a lien is available to the claimant as being only a question of procedure of the court seized with the case. The Supreme Court of Canada is hold cargo system v. ABC content liners confirmed the right of secured creditors, including claimants of maritime liens stated by virtue of foreign law, to realize of the security wherever the ships may be found in Canada. The court held that this could be done notwithstanding bankruptcy jurisdictions on the part of the foreign court of the domicile of the debtor who was seeking the turnover of funds from a judicial sale for the purpose of distribution in accordance with the applicable law of the forum, include the right to determine the identity of lien holders. Needless to say, the Supreme Court was well aware that the Belgian courts would not recognize U.S. liens in favor of goods and service providers. The court confirmed its position that notwithstanding the UK decisions in the Halcyon Isle in Canada, the determination whether or not a claim is secured by a maritime lien is not a claim is secured by a maritime lien is a question of the substantive law with which the cause of actions was closely connected, and not the questions of a procedure of the court. Unless there are public policy issues militating against the recognition of the foreign lien right, it will be recognized and enforced in Canada. In hot cargo, U.S. claimants were able to exercise maritime liens granted under U.S. law for stevedoring services and supply of wool. As well as the Federal Court of Appeal has issued 3 decisions closely connected with the issue of recognition and enforcement of foreign lien right. These decisions deal with the enforcement of supply contract lien clauses against vessels owned by third parties who are totally unaware of this contract. In Imperial Oil Limited v. Petromar Inc. 2001 FCA 391. A ship manager purportedly acting on behalf of a demissator entered into a supply agreement with the American bunker broker for the supply of goods in Canada. The court was not satisfied with the evidence that had been led as to whether the ship's manager was acting on behalf of the demissator on its own account. Notwithstanding the U.S. lien clause in the contract, the court found the determination of the law governing the lien is not the same as the governing law of the contract itself, because the intent of parties to a contract cannot bind the right of third parties. As this was the first case in Canada to pose the problem of characterizations of the governing law of the lien, the court made express reference to U.S. case law, and most notably the connecting factors test to be found in the judgment of the Supreme Court of the United States in Lawrence. The court found that one of the factors having greater weight than the others was the law governing the place of delivery of the goods, as in this case the bunker were being delivered in Canada, and to incidentally a Canadian registered ships. The court found that the factor connecting the lien for the United States were not strong enough to override the ship owner's right and dismiss the action. In a second decision, purportedly following Imperial Oil, a differently constituted panel of the Federal Court of Appeal in Richardson International v. the Miss Chickacheva upheld the U.S. lien clause in the contract between the demissator and the U.S. supplier on the ground that the procurement of supplies originated in the United States, that demissator under U.S. law can create liens against the vessel they demise, and because the contract of supply was included in series of transactions involving a loan of monies with the U.S. supplier acting as lender. So the time is up. The article will be continued to read on the next video. So bye bye and don't forget to like, comment and subscribe.